Selling cars, we'll buy.
Welcome back to the PI show. Before the break, we were watching TAC frequently asked questions, and there were just a whole host of questions that were asked, that were answered, and as I say, I think it's a helpful DVD. Bruce, you were involved, I think, in setting up what's called protocols, which are, I think, alternate dispute resolution or protocols which assist people who are injured who are disputing claims or to arrive at sort of sensible decisions, if you like. They're introduced in, what, 2004 in Victoria?
Yeah, 2005, yeah. That's
in five,
right.
were they?
Yep.
Yeah. And what are the protocols? Is it...
Basically, they're a set of agreed guidelines that were drawn up between TAC and the legal stakeholders at the time and signed off by the government, which set out the parameters around how a dispute would be managed and how essentially all the information that's required to resolve the dispute should be put on the table as early as possible, and then the parties would come together and resolve the matter without the need for litigation or for it to go before a tribunal. And they've proven to be very successful in achieving that outcome, that most cases don't need to go through that litigation process. We'd still like to see some improvement in the speed with which information is exchanged between the parties, but overall they've been very successful in ensuring clients get their cases resolved outside the litigation process.
What one real benefit, I think, is the speed in which matters can be decided and determined. Because historically, I think, before the protocols, it's fair to say that there were quite lengthy delays.
The average, Harry, in the protocol on the first page was the claimant's transport accident to be reduced from 60 months, 5 years, that was the average, to less than 30 months. So the idea of the protocols is to cut that time in half and also to speed up the common law serious injury certificate, to the granting from when that was 12 months now down to 6 months, and also the resolution of costs. Because Bruce, it seems to me to introduce some element of flexibility and, dare I say, common sense into trying to resolve disputes. And dare I say, TAC could impart that into perhaps the VWA at some point in time.
Well, I believe the VWA, my understanding is they have their own
they
pre-litigation process.
They do.
Which I understand works in many ways quite successfully as well, but
it's a lot more rigid and fixed, I think, than the TAC protocols. I think, to credit to the TAC, is that their protocols seem to me to have an element of flexibility and ability to deliver some benefit or resolution in a lot speedier way than the VWA.
Okay, well,
so that's my that's my. Perhaps you can't comment on that, but
they've got the benefit of hindsight. I think you're right, Harry. The VWA brought in the ministerial guidelines, I think, in 2001. TAC did this in 2005. They had the benefit of improving what was there. It also deals with the no-fault disputes, some of the issues which was on the DVD.
That's
there
right.
is
yes, if someone doesn't agree with a decision, any decision that TAC makes about their benefits, so if it's to assess the rate of income that we'll pay them or any item, then they can actually ask for that matter to be reviewed under the protocols, and often cases are resolved through that process as opposed to it needing to go to the Victorian Civil Administrative Tribunal. So, yeah.
And you've seen a reduction in timelines, and you've seen...
Definitely, yeah. We're well on the way to achieving those timeframes. We're not there yet. After 4 years, we're still working with the legal stakeholders closely to ensure that we do achieve ultimately those goals that were set out 4 years ago.
Right. It all depends, though, fortunately or unfortunately, on people lodging a claim. You don't get involved until a claim has been lodged, and then the process begins.
That's correct.
Okay.
And it's important that people lodge that claim within 12 months of the accident.
That's right. And if there's children involved, there's some exceptions for them until they're 18 years of age.
That's right.
They get dealt with a little differently. And as you say, once the process begins, people have their entitlements, and TAC will move forward with a claim.
Correct.
Okay.
But I mean, Bruce, ultimately the protocols are one step, and ultimately if people aren't happy for whatever reason, or there are bona fide issues in dispute, then ultimately people do go to court and
exactly, Harry, and that's still their entitlement, and TAC understands that sometimes that has to happen. Yeah,
it does. But I think, have you got information about how many matters are resolved under the protocols?
Yeah, so at the moment, with common law damages cases, as an example, it's in excess of 60% of our cases are now resolving through the protocol process, and we would like to see that in excess of 80 or 90%, but there are still some legal firms out there who choose not to use the protocols, and so that affects the percentage. But the firms that do participate, the percentage is very high that is resolving in that pre-litigation process.
Yeah, and as I say, really the advantage is there's an element of flexibility. There's no rigid timelines.
Yeah, that's right.
If you've got a very serious injury, you can then apply within a reasonably short period of time and have your case resolved.
And the parties sit down and talk face to face about the issues, and we think that's the best way to deal with the situation.
Yeah.
And as I say, your view is that you share some information with the VWA, but a number of years ago there was some proposal for marriage, that there'd been amalgamation of work cover and TAC, but that never really took off the ground. I think the politicians thought it was too hard.
Look, I think both schemes are quite different in many respects, and what we've done, TAC and WorkSafe in recent years, has collaborated where it's appropriate on things such as with the healthcare professionals with those industries, and trying to work with them across both schemes to get the right outcome for injured transport accident victims and injured workers. So we're collaborating in a number of areas, but there's certainly no discussion to my knowledge of anything further beyond that.
No. But as you say, there's impairments that are sort of similar. The common law test of serious injury is really similar as well.
Similar,
the courts
yeah, that's right.
have sort of
that's right.
seen them as really one and the same. The wording's slightly different.
Yeah,
yeah. One and the same sort of test. But all right, well, that's all we've got time for this week. Thanks very much for coming on board.
Thanks,
as I say, Bruce, you're a very unusual person, and you've a long-serving person with the TAC. It's just full credit to you.
Thanks, Harry.
Thanks for watching.
Martin.
Thank you.
And don't forget to, any questions you've got, this show or any other show, please log on to our website and send questions in. Thanks very much for watching.
Thank you.